Okay, we're at dinner after Psalms' triumphant performance. Judah, we're all relaxing. Say hi to mommy. Say hi, mommy. Miss Zion eating her cone. And our performer of the evening. And with that, we'll say goodnight. I'm at my storage here in Dallas, Texas. It's all the stuff I own right there. What's up, fam? I am now in Reno, Nevada. I'm here taking a break from the golf a little bit, trying to get custody of my kids, 50-50 rather. And here is right in front of the homeless shelter downtown. It's cold, right? So you gotta find somewhere to crash at night. It's been an eye-awakening experience. So once I make it to where I'm going, definitely gonna get back to institutions like Volunteers of America and the family shelters and the gospel mission here in Reno, because wow, they're really saving some lives. So I just got over this is Martin Luther King weekend 2019. Just got over a 4-day flu that kicked my tail. So just signed up for the Reno Works program, have an interview today. So luckily I'm strong enough to go down there and do that interview. But I'm here to fight for my kids. Had to put the golf on hold for a minute and reprioritize, because family's always first. So that's the focus, and I'll see you guys next time. Yo, here in Reno, Nevada. I'm in a program called Reno Works. Help develop people in the homeless shelter, get them back in society as productive citizens. So, just part of my journey, peeps. Stay tuned. What's up, fam? Just at the shelter, Reno, Nevada. Part of the process and getting to the end goal. That's why you don't ask what I got to go through to get there, because if God showed you, you would say, never mind.
Could the party stand up and raise their right hands to be sworn in?
Do you each solemnly swear that the testimony you're about to give shall be the truth, the whole truth?
Okay.
But I'll give you a trial on it with
Okay.
the complaint.
Okay.
Okay, have a seat.
For motion and temporary spousal support, that matter's been handled, but I have documentation here that puts the plaintiff in contempt for perjury, and I have the documentation where she stated under oath that I did not move the family to Hawaii and I hadn't seen the kids, and she stated that I had been somewhere playing golf somewhere, but I have documentation. I have been actively involved in my kids' lives. I have documentation of travel, I have documentation of pictures and everything.
Okay.
Financial circumstance at least has to be represented to the court, though there's about $25,000 unaccounted for that he received.
Objection, Your Honor.
What's your objection?
That agreement was a poor dissatisfaction. It's been taken care of. It has no bearing on this hearing right now.
Here that your gross monthly income is $1,493.
Yes, that was before I moved here. And in my motion, I explained everything, that I was in transition to come and for this hearing, since I had to defend it.
And that was for the period of ending December 15, 2018. Your gross year-to-date income was $18,000. That's what you have in your statement. It says your gross income at the end of December 15, 2018, year to date was 18,000.
Okay.
So what was the 18,000 from?
That was a combination of Uber, Lyft, and working a valet job
Okay, and where were you doing those things?
in Dallas, Texas.
Order. I understand that just the current status has been sole physical and legal.
Okay, but do the two of you talk,
Yeah.
ma'am?
Yes, Your Honor, about the kids.
Okay, do you do it, do you actually, I mean, most people use electronic communication. Are you actually talking?
No, Your Honor.
How do you communicate?
Electronic.
Is it text or email?
Text, Your Honor.
Text? Do you have access to the internet, sir?
Yes, Your Honor, I do.
On your phone?
Yes.
Okay. So I want you both to try out a program called Talking Parents and see how we can move towards joint legal custody. So Talking Parents is high conflict, which you're telling me you don't have high conflict, but you also tell me you communicate only electronically, so that suggests some challenges. So I want you to use a Talking Parents program, sign up within 72 hours. All information about the children, not about the other parts of the case, just the children will be communicated through that. You understand? The court can go into that program and review your communication with each other. So be aware that this is court ordered and can be court monitored. And it's to determine how well the two of you work together to meet the needs of your children. Okay? So, you know, it sounds like you already know when all the games are and all the events are. You can also convey that through Talking Parents. It sounds like you already know what schools they go to, so you can keep track of their schools without Talking Parents. But it's a way to start talking about when visitation will happen, whether it's happened, how long it's going to take. Just start using that tool. It's completely free, okay?
Yes, Your Honor.
I'm also going to have you participate in a program called Children in Between. It's got a $25 fee. I will waive it for you, sir, and ma'am, you must pay the $25 fee.
Yes, Your Honor.
And then the trial date will be June 12th at 9 a.m. The parties agree to work informally for father's visitation. The parties are ordered into mediation, and I'll suggest that the mediation be set out about 45 days just to give you time to settle in more, hopefully stabilize your housing situation so that you really know what is going to be what by the time you get to mediation. Maybe you'll get back into your transportation work, maybe you'll get other work, but that in valet work, there's always jobs for valet people, so those are good opportunities. I'll waive the fee for that for both of you. That fee is $300 otherwise. And then I'd like you both to file updated financial declaration statements 10 days before the trial. And I will devote the first hour of the trial to settlement. And sir, settlement is when you discuss off the record whether or not there's a way to come to an agreement without having to go to trial.
Your Honor, where are we in regards to discovery?
So I'm limiting discovery to those matters not already addressed in the marital settlement agreement, but I will allow discovery if you are alleging that there's been fraud in the creation or entry of the marital settlement agreement. You may discover those issues. So it's limited discovery. Okay?
Perfect.
And then neither of you, and you sound like you are very gentle with each other and the children, neither of you may disparage the other parent or the other parent's circumstances in the presence of the children, or allow other people to say negative things about the other parent in the presence of the children. So we've covered custody visitation, reserve child support, limit discovery but allow it, set mediation, set trial date. Is there anything else I need to address from you?
Your Honor, I noted that there was no specific language as far as jurisdiction or forum in the document, so it could be under Nevada law.
Well, you're right. Custody is going to be under Nevada law. Physical and legal. Child support is going to be under Nevada law. But whether the document meets the standards of the state of Virginia specifically is addressed in there. So I have to apply Virginia law in reviewing the document itself for propriety. Does anyone disagree with that?
I don't, Your Honor. I think that is the correct analysis. One of the things then, if I may request, I don't know maybe catching Mr. Doucette Perry, our reply to the MSA would be due today. We can put in a better supplement on the law, and maybe the way to do that vis-a-vis the MSA, which I would grant Mr. Doucette Perry the opportunity, if he wants to supplement his current opposition to the MSA and follow the court's
That's fine,
guidance
so you have
today.
10 days to submit your reply, and then you have an additional 10 days to file a supplemental opposition,
Thank you.
because Mr. Lucas is getting an extension on the time he has to file a reply, and so I'm giving you an opportunity to file a supplemental opposition after you read what he says.
Okay.
Okay?
And we'll try to focus it on the choice of law issues to those particular components, because I think that was somewhat the way that we had set up the original MSA. The opposition was a little bit
Okay.
off focus.
So are you an e-filer, sir?
I am.
So you're getting your notices by your phone,
Yes, ma'am.
and that's sufficient for you?
Yes.
Okay, that's great. Good job. All
Thank
right,
you.
the order will enter. Good luck to both of you. We'll see you in June unless you settle this case beforehand.
Thank you, Your Honor.
All right, good luck.
All rise.
And then up above that, it says general assessment 2018, and it's 303,400. So would I be correct in stating that there was equity in that property of about $50,000 plus dollars?
Objection like a foundation.
It's sustained, but this is in effect cross-examination, so I'm going to allow the question. Objection overruled.
Yes.
Okay. And that $50,000, it was not disclosed on your financial disclosure form. Can you tell me why?
No.
The next page states August 9th, 2013, sold for $555,000.
I don't know where you're looking, sir.
Oh, it's the next exhibit under the 91-1022 Cayuga Street, Ever Beach.
Okay, the Hawaii house.
Yes.
Why don't you just ask what the equity was in it?
Okay. I thought there had to be some procedural thing that
Nah.
we're about. Yeah, what was the equity in that house, Mr. Sekri?
Let's see, about $100,000.
Is there any reason why that wasn't produced on your financial disclosure form?
I don't know.
But you received the proceeds from that home.
I did,
Is there any reason why those proceeds were not produced on your financial disclosure form?
because they are not in my financial estate at the moment.
But at the time you received the funds, that was considered income. Why was it not produced?
Well, A, you can't testify that it was considered income. B, it wasn't at the same time she did her financial disclosure form. I don't know the date of the sale of the Hawaii home, but
June 1, 2018, sir.
okay, so this case was filed in October of 2018. So,
It's less than 6 months.
yeah, and it's that's why it's not in the financial disclosure form, or maybe that's why it's not in the financial disclosure form. I see your point. We'll give it the significance to which it's entitled.
Thank you, Your Honor. Your Honor, I would like to take judicial notice for this document.
That'll be yours. Without objection, I think.
Exhibit 12, please. In the email to Mr. Rydalek dated December 18, 2013,
That'll be the second page of 12, then, is that what you're
yes,
talking
actually the third.
about? Okay.
Can you read where it says, "Thanks, Mr. Rydalek"?
Thanks, Mr. Rydell. I've read through the draft. Only a couple of questions, probably easier to address when we meet to review. Should I call your office to schedule an appointment? Thanks again. Maria disagree.
And on the next page, where you said, "Good afternoon, Mr. Rydell."
Okay. Good afternoon, Mr. Rydell. Please find attached my completed separation agreement worksheet. Please confirm receipt of this email and advise whether I should call to schedule an appointment or if I should wait to receive something back from you first. Please feel free to contact me if additional information is required. Thanks for your assistance. Respectfully, Maria disagree. 703-586-2010.
Thank you. Wouldn't you agree that if we both did the worksheets, that your vernacular would state things of plural nature instead of singular nature?
I don't know.
I mean, you're an attorney, correct?
Yes, I am.
Overruled.
Yes, I am.
So wouldn't that be worded correctly as to say we and our instead of my?
In addition to her experience as an attorney, Maria was represented by counsel below. James, on the other hand, who moved to Nevada to fight for his family, was destitute. He lived in a homeless shelter throughout much of the proceedings below. At every opportunity where the trial court could have addressed this imbalance of power, it refused to do so. It rejected James's requests for temporary spousal support and for temporary attorney's fees. It expressed its desire to wrap up the proceedings as quickly as possible, stating as early as 3 months prior to trial, quote, "I don't want you to waste the time of the court when almost all of your case has already been decided." In an effort to bring the proceedings to a rapid close, the court exempted Maria from Rule 16.2's mandatory disclosures and limited discovery and trial to the issues of custody, visitation, and whether James could prove that he had been fraudulently induced into signing the agreement. On that issue, the court misapplied the burden of proof, placing it on James, when under both Nevada and Virginia law, it should have been Maria's burden to prove by clear and convincing evidence that the agreement was free of fraud or professional overreach. Having determined that James's testimony was not enough to meet the court's mistaken burden of proof, it incorporated the couple's agreement into its order in its entirety, save for on the issues of custody and visitation.
Right now, one of the purposes of having the district judge do findings like this in a family law cases, there's Nevada, a line in Nevada cases that says it's not just that the district court considered some of these factors and they look pretty good. There's actually a requirement that the district court has to show that it considered all of the factors. Now, there may be factors that don't apply to every individual case, but the district court has to include in its order some indication that we can see that it went through all of the statutory factors. And, this order is written in kind of an unusual way. There's, I can see what the district judge did. I can't remember if it's a he or a she, tried to make it kind of readable. So you have these long paragraphs that are kind of interesting to read, but it also makes it really hard to match up against the statute and figure out what finding relates to what statutory requirement. Can you, I'm just not sure how we're supposed to gather from this kind of narrative that all the factors have been considered.
I don't disagree with you. It's Mr. Bleeman. On behalf of Ms. Doucette-Perry, you've agreed with Judge Talbot essentially that the order doesn't comply with the cases from the Nevada Supreme Court. So you have to find some other way to support it. Is that correct?
Yes, I agree that it does not provide a specific analysis of each best interest factor.
So what about the very initial decision made pre-trial that the MSA wouldn't control, even though it had already set forth custody, and that was supposed to be a settlement of custody, but it was from 2013, and then the trial, was many years later. Theoretically, can't you just put in the MSA that this is it, and we've agreed, we've settled this issue, we're done, we don't even have to get into custody at trial? Or does the court always have to get into custody because the best interest must be considered, the factors must be looked at, and particularly when there's a long delay like in this case? Situation any different at the time of trial since Mr. Doucette Perry has moved to Reno at that point? He says he wants joint custody. He says he wants time with his kids. He's there for his kids, and so the situation's different. So now the court has to look at the present situation and project to the future, and not just look at the past situation.
Mr. Fleeman, let me ask a question. Would you agree that the divorce decree does not lay out the parenting time schedule with any degree of particularity?
To follow up on what Judge Bullis said, didn't both parties say that a plan could be put in place? And you can have a generalized plan, you can have teenage discretion, you can do various things. But right now there's no plan, it's just in the discretion of mom. And she acts in good faith, there's nothing to suggest she doesn't. But the problem of enforceability is really tough because there's no specificity.
Right, the enforceability would have to be that if he believes that she's not acting in good faith or that there's a problem, that it should be modified or clarified to give him time, but that hasn't occurred to my knowledge.
I mean, that's one of the, I was going to say, that's one of the funny things about contracts is really the purpose of writing contracts is for litigation. When things are going great, nobody needs a contract because nothing's going to end up in court. Written contracts of any kind, not just divorce decrees, but commercial contracts, they only matter when things go wrong. That's the point of having them, is for the situations when things go wrong. So the concern here is, what you're telling us is things are going great. Well, if things are going great, we wouldn't need this at all. But what happens when things go wrong? What does all this verbiage in here mean? And how is the court supposed to resolve this?
We'll move on now to the rebuttal argument from Ms. McFarling.
Good afternoon. Emily McFarling, appearing on behalf of the appellant. We're asking today for you to reverse and remand many different parts of the court's orders for quite a few different reasons. And the orders begin from this agreement that the parties had prepared and signed a long time ago, but we have so many different elements that stem from it that get us to where we are today. On the property and debt division and alimony issues, you have two options for where you can go with that if you find that this agreement wasn't properly handled in the district court. And as we heard earlier, there are a lot of different ways that it was not handled properly. Respondent argued that the heart of this is that you have to find that James signed with full knowledge that Maria was not acting as his attorney. That's not the standard here. We have these cases out of Virginia that are very clear and set a very high burden on Maria to have this agreement upheld when it finally does come to court, and she just simply can't meet that burden.
Yes, Marlene, can you point us to any evidence in the record that suggests there was fraud in the inducement other than they were married and that she was a lawyer?
Here's the problem with that question and being asked that at this point in time. James was not allowed to do full discovery. He was not allowed to do much of anything to prepare for trial. He was constantly told that the burden was placed on him by several different judges, and even though there were different judges, how they handled this case was very similar to each other. And at trial, he wasn't given that opportunity or even informed that was something that he could argue. So while there isn't a very extensive record on it,
The discovery order clearly allowed him to pursue evidence on this issue of fraud and the inducement, so he was not restricted in any way. And even if he did no discovery, couldn't he just come into court and explain the circumstances about why he believed that she was his lawyer at that moment in time, even though he was in Texas, they were separated, and she was in Virginia?
In a perfect world, yes, but the problem with this case is that there were so many mistakes and so many ways that he was disadvantaged leading up to that point that there's no way that he possibly could have even been prepared to put on that case. You say, yeah, he was allowed to do discovery, but he had admissions that he asked and they weren't answered, and he tried to get remedy from that from the court. And he wasn't. So even though, yeah, he technically was allowed to do discovery in the discovery order, he wasn't. And they didn't allow him to actually get the discovery when he brought it before the court. So it was lip service on him even having that limited right to discovery on that limited issue.
Well, let me ask you this as a practical matter, okay? In a corporate case, a commercial contract case, you allege fraud. I can imagine all kinds of discovery you'd want to get. Emails from the CEO to the vice president. You want to get, emails from the sales rep, all the kind of stuff. This is a contract between two people, a husband and a wife. What discovery are you talking about? She's not going to have documents. She doesn't have meeting minutes. There's no corporate charter. I mean, what discovery are you talking about as a practical matter in terms of evidence that she defrauded him?
I mean, the problem with this case is I don't know the answer to that because he wasn't allowed to really go down that road. Not just because of the limited discovery, but because of him constantly being told that he had the burden to prove that. And so there isn't, the information isn't in the record sufficient for me to comment on it or for you to make a determination. That's why this case needs to be reversed and remanded, either with this agreement found void or for further proceedings where it is very clear who has the burden, that there can be full discovery done, and that the proceedings are handled correctly. And if that happens, then he should be able to present that. In addition, on making sure that he can put on a proper case when the court reviews temporary orders for preliminary fees or for spousal support, this court should direct that they have to take into account that these parties need to be able to come to court on an equal footing. One of the huge problems is just that huge disparity in an attorney who had an attorney and an indigent man who has no representation at all to even be able to put on a case on a complex legal issue.
All right, thank you, Ms. McFarland. You ended up getting your 5 minutes that you had reserved. And you're fighting hard. You're fighting hard for him. I mean, obviously there's a problem on the surface because of what you just said. And so we will have to grapple with that. And you did your usual excellent work. And you had quite a co-counsel there today. So hopefully this is the start of a long career.
What's up, fam? I am now in Reno, Nevada, on the bus, on my way home. Just got out of the shelter about a month ago. Got my own place. And that's one thing, it's like when you've been living homeless for 5-6 years and you get a little 2-bedroom apartment, it feels like a mansion. So just stay focused, keep God first, and watch what He does in your life. Today is July 28, 2019, so stay tuned for the rest of the story.
Hey, decided to hang out in Sacramento, California, do a road trip with my son. It's a beautiful day, festive atmosphere, love it. Take care, be blessed.